Thank you so much for joining us today to discuss changes taken by the EEOC. I'm Katherine Brustowicz, and I'm joined today by my colleague David Gabor. We've worked together for the better part of a decade now, and we frequently present on new and pertinent employment law issues with an attempt to keep our employer-side clients and potential new clients informed of matters that may directly impact their business and their workforce. Today's webinar is no different. We're looking forward to spending the next 45 minutes with you. I'll jump into the high-level agenda to give you a sense of what you have to look forward to. We'll begin with an overview of the EEOC's historical enforcement guidance and discuss some of its evolution since its inception. Next, we'll jump to the EEOC's recent decision to rescind the comprehensive 2024 harassment enforcement guidance. That will flow pretty naturally into a discussion on the impact of the rescission, the EEOC's current focus, as well as recent developments with the Commission, and we will then explain best practices for employers. And we'll end our webinar with our typical top 10 list of take-home or takeaways for you. Now, before I get too far into the meat and potatoes, I'd like to remind our webinar attendees that if you happen to run into any technical issues during the webinar, please email webinar@wagnerlawgroup.com. That email address is also listed in the top right-hand corner of this agenda slide. All right. So initial guidelines and enforcement strategies were initially developed by the EEOC back in the 1960s. Keep in mind that the EEOC was created to enforce Title VII of the Civil Rights Act of 1964, and the Commission truly hit the ground running in 1965. That was 61 years ago. We didn't see significant enforcement policies focusing on harassment, retaliation, or discrimination being updated until the last several decades. The 1990s guidance was rather comprehensive, and that was largely because the Americans with Disabilities Act, the ADA, and the Older Workers Benefit Protections Act of 1990 both went into effect in the 90s. The OWBPA amended ADEA to prohibit age discrimination in employee benefits, and it established minimum standards for an employee's voluntary waiver of an ADEA claim. The EEOC also released the Americans with Disabilities Act Technical Assistance Manual, which was essentially a practical guide for both workers with disabilities as well as for employers. Also in the 90s, I believe it was in 1997, the EEOC created its very own website. This new development essentially provided the public with better access to information about the agency and the laws which it enforces. If you fast forward into the 2000s, the EEOC issued further guidance to augment what was already in place regarding the ADA. It specifically addressed disability-related inquiries and medical examinations of employees under the ADA. In 2007, the Commission issued the enforcement guidance on unlawful disparate treatment of workers with caregiving responsibilities. In 2012, new guidance provided information to employers on the disparate impact analysis and the defense of job-related and consistent with business necessity as applied to the use of criminal records and background checks to screen job applicants. In 2014, the EEOC addressed religious garb and grooming in the workplace. It revised more technical assistance documents regarding the ADA and updates to background check matters. In 2015, the EEOC issued enforcement guidance addressing pregnancy discrimination and related employment issues. Then, in the summer of 2016, the EEOC augmented their enforcement guidance to also include retaliation with specific examples. They focused on Title VII's prohibition on national origin discrimination in employment. So that's when they're taking a look at when an individual or perhaps their ancestors belong to a protected class from a certain place, or maybe they have the physical or cultural or linguistic characteristics of a particular national origin group. But the most major and significant update to the guidance in nearly a quarter century came in 2024. And that happened to coincide with the EEOC's celebration of the 60th anniversary of the Civil Rights Act of 1964. In April of 24, the Commission introduced comprehensive guidance on workplace harassment. Now, when I say comprehensive, I mean that the guidance was over 200 pages long and included more than 6 dozen concrete examples of various types of workplace harassment. This included illustrations of online harassment, harassment occurring during video meetings or through work chats, and virtual workplace harassment. The 2024 guidance also included detailed interpretations of LGBTQ plus harassment and pregnancy-related issues. The EEOC's guidance explained what a hostile work environment is. They explained it clearly. The guidance updated and replaced 5 previously issued EEOC guidance documents, and it served as a unified agency resource on EEOC enforced workplace harassment laws. The focus then was on protecting vulnerable workers, those in low-wage industries, and those belonging to minority groups. These were all new developments from the previous versions of guidance issued by the EEOC. And the next major evolution came just recently, and I'll let David discuss the decision to rescind the 2024 guidance.
Thank you very much, Katherine, and hello, everybody. We appreciate you joining us for this webinar. On January 22nd, 2026, the EEOC voted 2-1. There were 3 commissioners at that time, and 2 voted to rescind the 2024 enforcement guidance on harassment in the workplace. 1 voted against rescission. The EEOC chair, Andrea Lucas, stated, rescinding this guidance does not give employers license to engage in unlawful harassment. Federal employment laws against discrimination, harassment, and retaliation, and Supreme Court precedent interpreting those laws remain firmly in place. She added, the EEOC is committed to even-handed enforcement of these laws. The agency will continue to be dedicated to preventing and remedying unlawful workplace harassment. Just prior to the vote to rescind, there was some back and forth, at which time she said, quote, employees will not lose any rights or remedies if this is rescinded. The other commissioner voting in favor of rescission, Brittany Panuccio, she explained it would be a disservice to employers, employees, and other stakeholders for the commission to do a partial rescission or revision rather than a complete rescission. She further explained that the majority felt that the 2024 guidance was impermissibly functioning as a substantive or legislative rulemaking body by interpreting Title VII beyond the statutory text. She stated that parts of the 2024 guidance had been successfully challenged in court. There was a case in 2025 in the United States District Court in Texas, which found several parts of the 2024 guidance were unlawful, and they were vacated by the court. Some of the things that court focused on were bathrooms, dress, pronoun usage in court cases, and the like. So let's jump to the next slide and get some of the reaction. And mind you, the comments that Katherine and I are making, these are not political statements. We're not adopting one side or another. We're simply telling you what's going on in our program. The lone commissioner to oppose rescission, Commissioner Kotagal, was appointed by President Biden. And as I said, she was the lone person to object to rescission. And she expressed concern, quote, instead of adopting a thoughtful and surgical approach to excise the sections that the majority disagrees with or to suggest an alternative, the Commission is throwing out the baby with the bathwater. Worse, it is doing so without public input. She also cautioned that rescinding the guidance removes best practices for employers. And several other groups have sounded the alarm about the impact that rescinding harassment guidance would have on the employer-employee relationship. Some referring to this as a clear void, an empty hole, and that is a concern that they expressed. And the others say this erodes key worker protection. Okay, so the decision to rescind should be looked at together with some of the executive orders that have come down in the last 2 years. For example, the executive order regarding diversity, equity, and inclusion, as well as Executive Order 14168, defending women from gender ideology extremism, and the new administration's shift to a binary interpretation of sex. So, with this background, Katherine, can you talk a bit about the impact?
Yes, absolutely. And thank you, David. So first, I want to talk a little bit about what was lost. The 200-page comprehensive document, which included over 70 examples and specific interpretations of LGBTQ plus harassment, online harassment, and virtual work, was lost. Those examples of prohibited conduct had helped employers to curb and also to correct workplace harassment. It had set employer standards in the sense that employers were equipped with concrete examples that helped them to identify and to mitigate the risk of workplace harassment. And it also helped employers to better understand the step-by-step method for conducting impartial investigations into the same. Without this guidance, employers are left to question the EEOC's positions on ongoing obligations under Title VII and U.S. Supreme Court precedent in cases like Bostock. The previous guidance had also explicitly defined intentional misgendering and dead naming. Dead naming is the practice of intentionally using a transgender or non-binary person's birth name or their former name without their consent, as well as the denial of bathroom access, which David mentioned, based on gender identity. Those three examples had been defined as potential sexual harassment under Title VII. So you'll hear us say this, time in and time again here because it's fundamentally important for employers to understand. The EEOC's new guidance is not legally binding precedent. What it is guidance with an attempt to establish the EEOC's analysis of standards for harassment and for employer liability with respect to harassment. And rescinding the 2024 guidance just makes it a little bit more challenging or a little bit more difficult for employers to ascertain what is specifically prohibited conduct. But we should ask ourselves, well, what does remain in place? The law itself, specifically Title VII, did not change. The agency's interpretive roadmap was just withdrawn. Employers are still responsible for managing the employer-employee relationship without specific guidance from the EEOC. Now, that being said, the EEOC still considers enforcement against harassment as a priority, despite having withdrawn the specific 2024 guidance document. Keep in mind that stricter or more specific state-level fair employment practice laws also remain in full legal effect. Even though the 2024 guidance was rescinded, which means that the detailed examples I discussed on topics like virtual harassment and specific LGBTQ plus issues were removed, the legal risk remains for employers to remain compliant with the law. Employers just have a little bit more discretion now. And the last point here, or I should say the last 3 points on this slide, are a little bit off topic with respect to the EEOC, but it's still very timely. We've seen a recent surge in the use of AI in the workplace as well as within the HR world. So please use it carefully, especially when you're conducting your research. As it says here, not all information that AI generates is completely accurate. So, don't do just a simple Google search and assume that the AI response is going to be completely accurate. Do a bigger, deeper dive. And remember also to keep the privacy of employees front of mind. Now, with that, David, I think I'll hand it back to you. Perhaps you can tell us a bit more about the EEOC's current focus.
Sure, thank you, Catherine. And it's been clear in the last year and a half or so that there's been a shift in the focus of the EEOC to protecting men and especially white men. And this can be illustrated by a press release. And by the way, employers, you don't want to be the subject of an EEOC press release. That's a bad thing. That's when they announce either the resolution of cases or they're taking on cases. So on February 18, the EEOC issued a press release saying that Coca-Cola Bottling Northeast violated Title VII when it excluded male employees from an employer-sponsored event. And according to the EEOC's lawsuit, in September of 2024, Bedford, New Hampshire headquartered Coca-Cola Northeast held a two-day employer-sponsored trip and networking event at the Mohegan Sun Casino and Resort in Connecticut. Coca-Cola Northeast privately invited female employees and then excused the female employees who attended the event from their normal work duties on those days, September 10 and September 11, 2024, and paid them their normal salary or wages without requiring them to use vacation or other paid time off. Coca-Cola Northeast did not invite any male employees to the event. The EEOC proclaimed, quote, Title VII of the Civil Rights Act of 1964 has long made the exclusion of one protected class of employees from an employer-sponsored event a violation of the law, close quote. And that was said by Katherine Eschbach, the acting EEOC General Counsel. Quote, excluding men from an employer-sponsored event is a violation of the EEOC it's a violation of the law, and the EEOC will act to remedy through litigation when necessary. The EEOC remains committed to ensuring that all people, men and women alike, enjoy equal access to all aspects of their employment, including participation in employer-sponsored events. So the lesson in this one is a employer-sponsored event, whether it's for men or for women or white people, people of color, people of one religion or another religion, will be a focus of the EEOC. And recently, there was a case in the Third Circuit where a white New Jersey cop had sued, saying that he was not promoted to chief because his town wanted to hire a racial minority. And the Third Circuit reversed that case and said the case can go forward, that the white police officer can continue to prosecute the case against the town. And that illustrates, two examples of what we should be mindful of. One of the cases that Katherine and I were talking about in preparing for the program was the Bostock versus Clayton County, and that's a Supreme Court 2020 decision that sexual orientation and gender identity discrimination is sex discrimination, and that is still the law. So, when we talk about this topic, you can see where it can get very confusing as you try to determine what are the steps you should be taking to both get the best people and the brightest people working for you without stepping over the line. Uh, and I think one of the most important things to put in the back of your mind, because we keep focusing on federal law or what's going on out of Washington, D.C., is we still have state laws. So there are instances where you may have a state law or a local law that tells you to be more aggressive in terms of things such as DEI, diversity initiatives, things along those lines. And that's what its state or local law is saying, and Washington's saying that you can't. So I think, that's a time where we can shift to some other thoughts on the EEOC's current focus. So, Katherine, if you want to take it away.
Sure. And thank you, David. I'm going to talk a little bit more about state and local laws as well. And, oftentimes state and local laws do provide broader protections than the various federal standards. So we'll delve into that in a bit more detail in just a couple of slides too. So here we have, you can see the general bullet points of what I'm going to discuss with respect to some of the additional current focus of the commission at the moment. Recent leadership shifts have definitely introduced a stronger focus on religious accommodations, scrutiny of DEI programs, protecting American workers from national origin discrimination, and enforcing sex-based protections. So let's go ahead and go through each of these. The first one that I wanted to discuss, and David sort of touched upon this briefly, the EEOC has increased their investigations into whether diversity, equity, and inclusion programs end up resulting in reverse discrimination. Put another way, the Commission is shifting from a supportive role of DEI to active enforcement against initiatives that may constitute reverse discrimination under Title VII. The scrutiny focuses specifically on quotas, on race and sex-based hiring, as well as exclusionary fellowship or mentorship programs. So we would advise employers to, be aware of this and please try to tailor your DEI programs accordingly. And this is something that David and I do routinely. We're well equipped and more than happy to help you if you need any assistance in either developing or tailoring your current DEI programs. The next focus that I wanted to discuss is the protection of American workers. We're seeing an intensified focus on discrimination based on national origin, specifically the targeting of hiring preferences for certain types of visa holders over U.S. workers. So the Commission is actively investigating job advertisements that unlawfully require or prefer specific visa statuses. So, for example, H-1B only or H-1B preferred. And the reason they're focusing on that is that there's a concern that those types of requirements or preferences would result in the exclusion of qualified American applicants. Now, going hand in hand with this, the EEOC has released guidance. It's titled Discrimination Against American Workers is Against the Law, end quote. And that is a one-page document which is currently available on the EEOC's website if you want to take a look at that. We've also seen a shift towards interpreting Title VII in line with protecting quote unquote biological distinct sexes and impacting policies on transgender employees. And the EEOC does continue to focus on workplace harassment despite the recent changes in the guidance. So that's the bullet point there on systemic harassment. That's still a priority and a focus. And the last change that I wanted to discuss is that the EEOC is currently emphasizing what they're calling organizational excellence. And the Commission is doing this by strengthening its investigation and litigation procedures to ensure faster and more impactful resolutions. One way that the EEOC is doing that is through enhancing their use of digital tools to improve services for the public. One example of that is that they have updated their online intake system and they have expanded their public portal. So it seems the EEOC has come a long way from introducing their initial website back in the day as a big development to now really updating their full online system and public portal. So, with these changes being nicely discussed, let's go ahead and talk about some best practices for employers.
Thanks, Catherine. So we both have slides on best practices. We want to share some things with you. Uh, we don't want you to think that all is doom and gloom or be overwhelmed by it, but we want to just have you prepared in advance so that you know how to adapt your practices and your policies to take into consideration what's coming out of the states, what's coming out of Washington. To that end, I think the first thing that it's a good idea to do is to take a close look at your policies. It's something you should be doing regardless of the rescission of the 2024 guidance. Um, some of our clients have policies that have not been updated since prior to the pandemic and don't take into consideration things like people working from home. So we do think that it's a good idea to update your policy, and you can use the 2024 guidance, if you want to help you with some of your policy language. But we also discourage you to automatically roll back provisions in your policies because of the fact that there's been a change. Something that I think Catherine and I both, say is there's a pendulum and it swings to the left and it swings to the right. So keep that in mind because, the reaction to the 2024 guidance, it may be in 2 or 3 or 4 years, that becomes the guidance again. It may not be, we don't know, but overreacting would for sure be a mistake. We do believe in training your teams and your managers. Whether you call it a harassment prevention training of the team or you call it a workplace civility type of training, do train your team. Make sure that they know that they have someone they can report to. The guidance from the Supreme Court in 1998 in Ellerth and Boca Raton was very clear. If you have an effective anti-harassment policy, there are people in place that an employee can report to and share their concerns and feel that they're doing so in a safe and appropriate environment. That's still what the Supreme Court expects. And that's consistent with Title VII, ADEA, and the ADA. So do train your teams. Um, and there's also an ROI in doing that in any event because employees who feel that they're working somewhere where they're cared about tend to be more productive and you have less unwanted turnover. At the same time, it's a good idea to train your managers so they know in advance what to do if an employee comes to them with an issue or a concern and they have clear understanding of what they are allowed to do and what they are not allowed to do. Excuse me. Communication with, your employees, clear, unambiguous communication is critical. We like to use words like voice and respect. If a person does communicate, they use their voice, they're encouraged to use their voice in a respectful way, and others should respond respectfully. When someone says something, or objects to something, I think that's important. And, at the same time, emphasize what the authority is at each layer of your organization. Proper investigations. Nothing about the rescission of the guidance should impact how you investigate complaints that are made. I think every time a person reports an issue or a concern, there should be some form of a reaction using the broader term investigation. But the scope and depth of the investigation varies depending upon the facts and circumstances. Another thing that has been a real concern is job descriptions. This is a bit of an aside. This and same with the Form I-9 audits. These are things that have a recurring themes or concerns that we deal with on a regular basis. Make sure the job description accurately reflects what the person's doing. Otherwise, you are at risk of potentially having an employee classification violation. I-9 auditing is hot in 2026, and I'm sure it's going to remain so throughout the year. And the last point I have on my side is do what you're doing now. Stay current on what's going on. And don't be afraid to ask questions of your legal advisors. Hey, Katherine, you got some best practices to share.
I do indeed. Before I jump into that, though, I did want to just piggyback on one of the points that you made, David. You were just talking about the importance of training, and one specific piece of training that I think cannot be overstated with respect to its importance is specifically training management on reporting procedures and on anti-retaliation. Those remain really high risk areas, and those are on the EEOC's radar, if you will. As you said, David, there are myriad different types of trainings that can be conducted, but I think specifically honing in on anti-discrimination and anti-retaliation are two very important areas for training these days.
Good call out, Katherine. Thank you very much.
Thank you. All right, so we'll continue on with a few more best practices. The first one here is focusing on objective criteria. So when you or your team are making hiring or firing or promotion decisions, please make sure that those decisions are based on clear, job-related, and non-discriminatory criteria. So this is going to help you as a business to help avoid the appearance of any illegal DEI efforts. That is high on the EEOC's radar right now. Just, you know, the DEI efforts that you have are not illegal. You just need to make sure that you are focusing on merit-based rather than the potential belonging to a particular class of people as being the reasons for making these hiring or firing or promotion decisions. And keep in mind that that also goes hand in hand with any type of mentoring programs that you might have. That should all be merit-based. You shouldn't be looking at the specific inclusion of being included in a particular type of class of people. And that goes back to the case that David had mentioned today about having a female-only retreat versus having everyone be included. So just keep that in mind. Objective criteria, merit-based rather than belonging to a particular class of people is going to be key going forward. Next is the review of accommodation requests. It's very important these days for employers to carefully evaluate requests for religious or medical accommodations, as these legal obligations absolutely remain intact. The EEOC has provided a lot of guidance on the ADA over the years, and the interactive process is still the law. Similar to what David had mentioned earlier, it's important for managers to be aware of how to handle these requests before the requests are actually made so that they don't inadvertently misstep. That proactive training is also going to help your management team feel better equipped. They're not going to feel blindsided, and they're not going to inadvertently, for example, not follow the interactive process, or maybe not give quite enough thought into whether or not a reasonable accommodation actually is available, without the business incurring any kind of undue burden or cost. Also, with the accommodation requests, make sure that you keep those requests private and always document the process. Document the decisions and document, how they were made or why they were made. Having clear documentation that is objective, may end up being exonerating for you down the line. And the last point that I wanted to make before we head into a review of our top 10 list, um, I actually did not list on this slide, so here's a little surprise bullet point for you. It's the best practice of monitoring legal developments. Please stay updated on court decisions and potential future, maybe narrower or updated guidance from the EEOC regarding harassment. The landscape is always shifting, and it is absolutely prudent to keep apprised of any changes that are coming down the pipeline. A little bit later, one of the key takeaways I'm going to discuss is, multi-jurisdictional compliance. That goes hand in hand with monitoring legal developments. If you have a business that operates out of several different states, or if you've got employees that are living in several different states, it's really important to keep up to date with any of those developments, because, as David and I both mentioned, oftentimes state or local laws are going to provide broader protections or broader rights than those under federal laws. So just prudent to keep your ears and eyes open on future developments, because we know that the employment law landscape is many things, but stagnant is not one of them. So with that, I think we are going to go ahead and delve into our top 10 list of takeaway points. Okay, so I see I've sort of preempted myself a little bit in this, but we'll start off with the first one. Uh, don't panic. Don't delete your policies. The legal obligations to maintain a harassment-free workplace truly does remain unchanged. We may have a little bit less guidance to work with right now with respect to specific examples of harassment, but Title VII remains the law. It is clear, and an employer's obligation does remain in full force and effect. So don't panic, don't overreact, don't cancel your policies. Just recall that your legal obligation as an employer to maintain a harassment-free workplace still exists.
Catherine talked about documenting, for example, was the interactive process. We push our clients to not just document, but get in the habit of documenting and what they should and should not document. Because what happens is we're all so busy. So an event takes place on March 10. Yeah, I'll make notes on it, March 11, March 12, something else comes up, and now we're a week later, and we totally forget to document. Or we make cryptic notes with handwriting that no one can read. If Catherine was off mute right now, she'd be laughing because she's seen my handwriting, and it gives her migraines when she tries to read it. But be that as it may, do take the time to make sure people on the team are documenting. If you don't document and it winds up in court down the road, the court may infer that the event never took place. I was in court one time, and the case before me was a case involving a major hotel chain, and they claimed they engaged in the interactive process, but there was no documentation of the process. And the judge said, as far as I'm concerned, no, you never did engage in the interactive process. Go settle the case. And that was a painful and financially troublesome result for that company. So do document. And I know Catherine's going to talk about this also, but the law where the employee works is controlling. So this is something that I think is an action item that is important. Your company is located in Boston. You have an employee who's working remotely in New York or Connecticut or Vermont. Well, that law in New York or Vermont or Connecticut may control the rights the employee has. Take the time to make sure you know where the employees are working. Catherine, you want to hit number four?
Yes, absolutely. Thank you, David. And I think that this next point actually dovetails nicely from what you were just saying with respect to the controlling laws where the employee works. Developments within the EEOC, as well as the developments surrounding executive orders, they do not impact state law. And I apologize, I do not mean to beat a dead horse, but please simply don't forget that state and local laws are still the law. The EEOC enforces the law. They will provide guidance that helps employers to understand how they're going to be enforcing the law, but the EEOC does not change the law. And the executive orders similarly do not change the federal law. They also don't change the state law. So when in doubt, just try your very best to remain in compliance with the law, be that federal, state, or local.
All right, Catherine, just piggyback a little bit on what you said earlier regarding staying current on legal developments. Uh, One of the ways of doing it is to attend webinars like this one, or make sure you're on the list to get alerts from law firms. But there are organizations like the Society of Human Resource Management that does issue updates on what's going on, what's hot, what's current and important. So for you folks in HR or for people on your team in HR, get them involved in SHRM and they can get the alerts on a regular basis. So Catherine, you love talking about multi-jurisdictional compliance. I know that's your favorite topic. Go for it.
It is actually one of my favorite topics because it can be a little bit complex, but it's super important. I think especially in today's day and age where we have employers who have employees working remotely from, dozens of different states. So that means that the employers need to suddenly be juggling dozens of different state laws. So while it can be a little bit complex and challenging, it's supremely important because this is a trap for the unwary. So please ensure that your state and local laws are the baseline if they happen to be more protective than the pertinent federal law. I've said it before and I'll say it again. State laws do vary from state to state pretty widely. So if you do have businesses or employees in multiple different states, keep up to date on the state law changes and ensure that you're staying in compliance with the strictest of the state laws. This is again an area of employment law that does shift quite a bit. Even simple things like frankly getting down to minimum wage that differs vastly from state to state. So keeping up to date with those changes is something that will help to keep you in compliance and it will help you to mitigate your risk as an employer.
Okay, I see we've got 2 minutes left, so I'm going to hit points 7 and 9 together and then leave it for Catherine to wrap this up. Um, if you centralize decision making as opposed to ad hoc decision making, that's going to go a long way towards ensuring that your employment actions are consistent. And a well-trained decision maker will reduce your risk of exposure to claims or claims that have merit, in this shifting landscape. Um, so this enables you to be consistent in your actions and how you treat people and how you're paying people in your promotion practices, in how you handle investigations. And I'm not going to stress it. We've said the D word enough already, but if you document what you're doing and you're under a microscope, you'll be in very good shape. Catherine, take it away.
Thank you. So the importance of a well-trained team truly cannot be overstated. So I won't overstate it again. But do be mindful also that, as David mentioned, the pendulum will likely swing in another direction in a couple of years. So create policies and a culture that's inclusive. It's not only the right thing to do, but it should also keep you out of harm's way with whatever should happen to unfold in future elections. And with the last few seconds that we have, I think we just wanted to briefly touch upon some of our other practice groups.
Oh, yes. We have a very robust team that handles ERISA, employee benefits, investment management, bankruptcy, restructuring, HIPAA, privacy, security, and you can see the rest of the names on the list. But we've got great colleagues here, and if you ever want an introduction to them, just reach out to Katherine or to me.
And with that, we thank you very much for your time. If you have any questions that we weren't able to address, please feel free to either email or call either of us. You've got our contact information there at the bottom of the slide.
Thank you again, everybody.